In South Africa, the legal nature of mineral rights is the cornerstone of our mining law. Governed by the Mineral and Petroleum Resource Development Act, or MPRDA. Mineral rights exist as limited real rights separate from the ownership of the land itself. This means that, while you may own the surface land, the minerals beneath are controlled by the state and regulated through statutory rights. Welcome back to City Education, your home for knowledge in all forms, shapes, and sizes. Now let's go deeper into mineral rights. Now let's go deeper into the separation. Section 5 of the Mineral and Petroleum Resource Development Act establishes that the ownership of minerals is separated from the land ownership. Holders of prospecting or mining rights are given specific powers, but they must respect the rights of landowners. For instance, in Jabard versus Miranda Mining Company 2009, the court confirmed that a mining right holder has the right to enter land, but only after proper notification and consultation with the landowner. Under Section 5, Subsection 3, the holder of a mineral right enjoys several rights, including, firstly, entering the land with employees, secondly, bringing in machinery and constructing infrastructure, thirdly, mining or prospecting for their own account, number 4, removing and disposing of minerals, number 5, using water for mining activities, and no 6, conducting incidental activities linked to mining. However, these rights must be balanced by strict duties under the MPRDA. Now, compliance lies at the heart of South Africa's mining law framework. The Mineral and Petroleum Resource Development Act makes it clear that no person may prospect or mine without proper authorization. This requirement is entrenched in Section 5A. Now, before operations begin, the rights holder must,
firstly,
obtain an environmental authorization, ensuring that activity does not cause unacceptable ecological harm. Secondly, secure a prospecting right, mining right, or permit from the Minister of Mineral Resource or their delegate. Thirdly, gave the landowner or lawful occupier at least 21 days written notice of the intention or intended activity. Importantly, the law does not require the landowner's consent, but meaningful consultation is mandatory. This ensures that landowners, lawful occupiers, and affected communities are informed and given a voice. Failure to comply with these obligations is a serious offense. Mining without proper authorization amounts to illegal mining, exposing companies to criminal liability, closure of operations, and heavy penalties. Thus, the duties of a mineral rights holder are not just about securing profits. They are about ensuring responsible mining that respects landowners, communities, and the environment. Now, under the Mineral and Petroleum Resource Development Act, South Africa distinguishes between prospecting rights and mining rights. A prospecting right allows a holder to search for minerals and is generally valid for 5 years. It grants exclusive. No other person can be given the same right over the same land and mineral during that time. A mining right, on the other hand, is a long-term right valid for 30 years and gives the holder the power to exploit the mineral resource on a commercial scale. Both rights are exclusive and must be directly applied for to the Minister of Mineral Resources or their delegated official, usually the regional general. But these rights come with strict conditions. The holder of a prospecting right must begin prospecting activities within 120 days of the right becoming effective. The holder of a mining right, on the other hand, must commence operations within 1 year of its approval. Holders must continuously and actively work their rights. Dormant rights are not protected. In addition, both rights are generally not transferable. They cannot be sold, leased, or ceded without the minister's written consent, protecting the state's custodianship of minerals. The law also ensures that the granting of these rights does not result in exclusionary practices or anti-competitive control of resources. An applicant must show technical and financial ability and prove that operations will not cause unacceptable environmental damage. Ultimately, a prospecting or mining right is more than a business license. It is a limited real right with weighty obligations designed to balance economic development with firmness, competition, and sustainability. Now, the Mineral and Petroleum Resource Development Act does not only regulate mining operations, it also provides thoughtful safeguards for communities and the environment. Section 1(4) of the Act gives communities a preferential right to apply for prospecting or mining on the land registered in their name. Although the term preferential right is not clearly defined, it signals recognition of the historical marginalization of communities in mining. The courts in the case of Ballooney and others, Minister of Mineral Resources 2019, has stated that affected communities must be meaningfully consulted before any mining rights are granted. Environmental protection is another cornerstone. Before granting any rights, the minister must be sure that mining will not cause any unacceptable ecological degradation or harm to water resources. Applicants are required to submit environmental management plans or programs, and compliance is continuously monitored. The duty to consult extends beyond landowners. It includes lawful occupiers, workers, and communities whose way of life may be disrupted. While consent is not required, the consultation must be genuine, transparent, and respectful. In practice, this means companies must engage local stakeholders, explain potential effects, and in some cases, provide compensation or community benefits. The African environmental and constitutional law also intersects here. Under Section 24 of the Constitution, everyone has the right to an environment that is not harmful to their health or well-being. This principle reinforces the idea that mining must be conducted responsibly, balancing economic development and environmental sustainability, as well as human rights. In conclusion, mineral rights under the MPRDA balance the state's custodianship of resources, the rights of landowners, and the obligations of rights holders. By treating mineral rights as limited real rights, South African law ensures that our mineral wealth is developed responsibly, sustainably, and fairly. If you found this video helpful, don't forget to like, share,
and subscribe.
And so we meet under the next one. This is City Education, your home for education in all forms, shapes, and sizes.